I just wanted to say, hey, it's 7 o'clock approximately in Alaska, and this is Free the People. I'm Maria, and my co-host is here. Say hi, Chris.
Hello, Chris.
Chris is here, and we're just rocking and rolling and getting ready to talk to Shelly Wyatt of Midnight Sun Channel, and also Travis Middleton of Simi Valley, California fame. So the first thing I wanted to say, though, is this is the day that the Senate acquitted Donald J. Trump in the phony, fake SMU impeachment proceedings. And I'm inviting anybody to beat me up over that or make comments on that later. But we just want to get on the recording that this is the day, that's what's happening kind of on the national, I guess you'd call it the international scene, since every one of our states are actually independent, free, sovereign, and independent nation states. But here I go getting a little bit into the weeds already. Let's just get back on track. So Shelly, tell us a little bit about your channel. We're going to plug it for you, and then talk a little bit about what you've figured out about the proclamation. And then if we have a minute, we'll go through some of that stuff we reviewed on the phone about how great that Task Force Alaska is gonna work out.
Okay. Thank you for having me. I do have a website up, and it's probably the best way to find. I have a few YouTube channels and a BitChute channel, and they kind of run me off. So the best place to probably regroup for daily videos would be at my website, which is themidnightsunstar.us. Yeah. They do run me around. I've had 2 or 3 channels on YouTube shut down, and they really hit me hard when I put together the Iran, what was going on over in Iran with the deep state. They just really, But it's not like the information wasn't always out there. And if you've followed geopolitics for more than just 3 years or 5 years, put some time into it, you really know when the propaganda started hitting hard, and then they're running everybody to another narrative. It's really interesting.
Sorry, I'm having to kind of...
Oh, you're just fine. You're just fine. Sorry. I usually have all kinds of words to say. I'm not really sure. I don't really usually talk about myself. I have a tendency on my videos. They're always news, and they're usually revolving around politics. And, there's just a better way. They make it like a cookie-cutter way. And then as we saw with the DNC caucus the other night, and they tried the ranked choice voting. Yeah, that was fascinating to see. They're blaming it on an app, but the app couldn't calculate it. It's very odd. I did have a couple people from Maine contact me with their last elections, and they said they did have ranked choice voting there. And they said it's all red except 2 counties that did ranked choice voting that were blue carried the whole state, and it really is just an assault on all fronts of, the people's everywhere. And it's divide and conquer everywhere. And I think that's excellent why the proclamation came out for Task Force Alaska. There's a lot going on, and we can see it before our very eyes, whatever system they've been running on. And it's not the system that itself. If we have checks and balances and nobody pays attention to them, and we the people set up laws, and then other laws take precedence over them, and then even those aren't held to, what good is it? It turns into the Wild West. we do know now that resist attorneys are they're an interesting, and also ACLU is in there too. They never took the oath after law school that most lawyers take, and they're leaning communism. And what they've done is pretty much hijacked the constitutional law that everybody knows. We're like, well, that's against my Bill of Rights, and that's my constitutional right. Why is this happening? It's because, think of Kevin Kleinsmith down in D.C. about 2 months ago. He is a resist lawyer, and he got busted falsifying the FISA document. That's what they do. And then they build case law on top of that, and it's like building your house on sand. It will crumble, and that's what we're seeing, the hijack crumble. And it doesn't, and it doesn't really help that we have mayors and, stuff like that when they should be doing the right thing instead of just glitz and glamour. It's really disheartening.
Well, I noticed that you put up the proclamation telling people about Task Force Alaska, and Chris alerted me today that you just kept mentioning it over and over and over again. And so I think most of the people on this call have heard about it, and now since our trip to Wasilla, that 500 people or however many were at the gun rally there this past weekend have heard about it. And I think it's going to bring a little bit of hope to this legislature. Yes, absolutely. Because people panic when they only think there's this choice, and we have to save this choice, even though it's crumbling away, and we can fix it. Well, it's always nice that there's a reason that's crumbling away, and until we, the peoples of Alaska, figure out this is how we're going to take back our power and not give them the power. That's just the thing. We didn't give them any power. They're just supposed to be representing us and then doing the best for the people that elected them. Like, hey, we need a little bit of whatever we need. Please go help us get it. Not run a coup, knock everybody off their committees and councils, and then put on the crown one ring to rule them all. That's a little much. And Alaskans are pretty much a different kind of breed of people. We just really are. Our zero tolerance level for garbage it's amazing. Like, we don't put up with it. And, it's good to be that way. Because, you have to stand for something or you'll fall for anything, for sure. Yeah. Well, I want to go ahead and introduce Travis and kind of explain. We'll come back around later and maybe discuss a little bit about what the task force was created to do. But I wanted to let people know how I ran into Travis. I was watching Minivan Jack, which is, of course, I'm not recalling, it's Jerry Day. It's Jerry Day's YouTube channel. And Jerry Day is the one who introduced us to who I call the red-haired lady. And the red-haired lady is Jackie Fig. And Jackie Fig is I think she's in California. And she is Jerry Day calls her the bravest woman in the world, and she basically figured out her duties, obligations, and responsibilities didn't include registering all of her private property with the state of California and giving it over to them. So anyway, I was watching Jerry's channel, and he was talking about Travis coming out of court, suing Simi Valley, California. And Simi Valley had just told him he lacked standing, among other things. And so I just went into the channel and I wrote a quick comment that we can take standing under a beneficial public interest, and we've had some success doing that here in Alaska when friends have been arrested for no good reason. We go in and take standing under beneficial public interest and speak up for them and stick up for them. So I put that into the comments, and then I wrote to Travis, and said, hey, what about standing on their beneficial public interest? And he wrote back about his writ of mandamus and a lot more in depth and involved in what what I had to offer. So I just wanted Travis to come on and give us some of your background, Travis. I've got your bio here. It says you're a legal researcher and lawyerless litigator. Hear, hear. We're all for that.
Yes, Maria, thanks for having me on. And yes, I got into studying law and process through a guy named Michael Brown. Michael Brown, back in 1971, was involved in law school, double majoring in electronics and law. When the Roe versus Wade case ruling came down in 72, he didn't like the ruling, and neither did 2 or 3 of his boys. They got together and decided they were going to bomb a federal building in protest. They get their C4, they pop into this federal building, something goes wrong, they all get caught. The other 2 or 3 turned on each other, and Michael Brown didn't turn. He ended up getting prosecuted and sentenced to 19 years in federal penitentiary in Terre Haute, Indiana, for terrorist acts against the country, of which he was certainly guilty of. Now, he got himself out in 36 months. So, but while he was inside, he met a guy named William Kimbrough. William Kimbrough he's an ex-attorney. I'm not sure what his legal background was. He was trained by Alger Hiss. Alger Hiss was Richard Nixon's law clerk. William Kimbrough's father was a federal judge, and his mother, I believe, was a federal prosecutor or something. But the reason why he was in prison, when Brown hit prison, he was a legal, law-abiding citizen that got tired of seeing the system screw people around, and he went sideways, started robbing banks. And he was due to get out in a few months as Brown was getting in. So as Brown was watching one day where this big jailer, 6'6", 300-pound jailer, was walking down the aisle to see Mr. Kimbrough, had his hands in the air as if he didn't want Kimbrough to harm him. And he said, I just want to talk to you, Mr. Kimbrough. I don't mean you any harm. And so he said his piece, and he left. And Brown was sort of bedazzled by this encounter and thought, why is this guy so afraid of you? He's a big 6'6" jailer. Here you are incarcerated. Why is he afraid of you? So Kimbrough goes, I sued him. And Brown goes, what? He goes, I sued him. He goes, how do you sue anybody inside this place? So Kimbrough talked to Brown and mentored him on how to, what they call, break an indictment and how to work the judicial system in spite of a corrupt judiciary. So that was Brown's mentor. Brown's now been out of prison 40-something years, been teaching attorneys and non-attorneys how our judicial system really works, some of the things they don't teach in law school, how to make a judge behave, those sorts of things. And he has a way of teaching people how to make a constitutional argument. So I got involved about 18 years ago, learned about law and process. I actually live in Santa Barbara. I don't live in Simi Valley. And one of the reasons why the judge in this case stated I didn't have any standing was because I wasn't a resident of Simi Valley. Now, as Maria, you read my legal sites in my email, all of it refers to as what's called a beneficial interest. In California, we have a California Supreme Court case law that states that anyone, any citizen, who could have a beneficial interest when there's a public duty that's owed of a public official and they're not doing that duty. Any individual that's a resident of California can put together a mandamus by right under California Articles Section 1(3)(a) to force this official to do that which they're sworn to do by a specific duty. So that's what we've been doing in the Ventura court. You know, the judge made the statement when we came on for the record. Let me back up a second. When we got to court, there was a note outside the door. that stated that the court reporters are available Monday through Friday, only between the hours of 1 o'clock and 1:30. That's lunchtime. And I guess they're available on the weekend. The court's not open on the weekends. So on Monday, the available times or they did have availability from 8 o'clock to 12, and then from 1:30 to 5:30. So essentially, they weren't available. But I had already submitted a notice to the court requesting a court reporter for all the proceedings. So when we got inside the court, there was a reporter, to my surprise. So the judge comes on the bench and he states, first off, a number of things. One, goes, Mr. Middle, you don't have any standing. You're not a resident of Simi Valley. Number two, he stated that Title 47 is United States law. There's no difference in the regulations versus the statute. And three, if you want to make a public official do something, go to the voting booth. So then he asked the opposing attorney if he wanted to make any remarks. He said, no, I'll just stand on the merits of my pleadings. And he did a roll call with everybody else. On the plaintiff's side, and there's 4 plaintiffs, including myself. He asked them if they wanted to make a speech or a statement. And I'd already coached them on making the statement. I stand on the merits of my pleadings before the court and sit down. So the judge can't try to trip you up in an argument. So I said to the judge, if you'd like, or if you don't mind, I wouldn't mind making a statement. He goes, okay, go ahead and speak. So I'm thinking to myself, he first said to me, I don't have any standing, yet he's allowed me to speak. And I began to state these words to him. Your Honor, we the petitioners respect your tentative ruling, however we disagree on several grounds. One, Title 47 is not law. There has to be regulations of enforcement backing it up, detailing who it's enforced upon. Number two, we have a constitutional right under California's law to do what we're doing, and I do have standing. And three, there's nothing mentioned in the code about voting. And the public officials have been essentially telling the people that their hands are tied and they have to follow this routine, this Regulatory Order 18-133. So he stops me and says to me, where does it say that? And I responded, it's in the brief. It's in the petition, Your Honor. He goes, but where? Where does it say it? I said, it's in the petition. He goes, well, where does it say it? I said, give me a second, I'll find it for you. And that told me that he hadn't read the petition, nor the opposition arguments. So I go to my petition, look at page 4, paragraph 11. If you'd like, I can read it for you. He goes, no, I've got it. He goes, well, there's no proof other than your allegation that their hands are tied. So I'm going to grant you leave to amend and be back here in 30 days with an amended pleading. So that's where we left it at that time. So now I'm finishing up my amended pleading, and I think what he is doing is being a gatekeeper. I think he wants to move the narrative into an area that he wants to see me go in, like voting rights or some other kind of public official duty. And I'm not going to do that. Part of the argument that I'm making in this mandamus is that public officials are sworn to uphold the law, state and federal. That's their first duty. Under California's Article 1, Section 3A, it states the people have the right to instruct their representatives. When I saw that 6 years ago, I had just been itching to get into the research to find out if that said what I thought it said. Turns out I have case law on that provision of California's Constitution, and it does state just that. The people have the right to instruct their representatives, as long as, one, the instructions are constitutional and that is a public official. That's an unqualified right Californians have, aside from voting. Voting is a different mechanism. So the judge wants to make the claim that voting is one we should be looking at versus what's called giving them an instruction. Now, the only way that I know how to actually instruct a representative is by mandamus. You can write letters, you can do petitions, you can hold signs up and protest, but those aren't instructions. Those are protests. So it was my idea for this 5G rollout in Simi Valley was to teach these individuals how to engage their public officials because they're not following their oath and they're not following the law on the books, state or federal. They're basically being shut out of the political process by the corruption of the city council and some consultant attorney that works for the telecom industry.
Right.
So that's the basis of what we're doing so far. And so we have leave to amend. I must submit my amended pleading on the 13th of next week. And so basically, I guess he wants me to submit a Quran, this huge book with all this evidence about the allegations that I'm going to submit. And I'm going to give it to him. But I think he still is leaning more toward probably dismiss it or say it's deficient somehow and force me to file an appeal. But you had a question. Go ahead.
I have a bunch of questions, but I didn't quite catch what it was in your pleadings that you wanted to amend. What were you amending?
Well, he didn't reduce his tentative ruling to what's called a written statements of facts, conclusions of law. Okay? What he did was come on the bench orally and stated that you have leave to amend. And the only thing that he really focused on was to ask me, where does it say in the petition where the city council members have said their hands are tied and they must follow this regulatory order? So I pointed it out to him where it was located in the verbiage. And he stated, okay, I'll give you leave to amend that section. Now, but he also stated other things, that I didn't have any standing, yet he let me speak. He said it was his judicial discretion that he let me speak.
Sure. Okay, so I wanted to take apart that standing under beneficial public interest in a minute. But I still don't understand if it was in your pleadings on page 4, whatever, paragraph or line 11 or whatever, what were you going to amend? What did you have to put back in there?
Well, he wants proof that one of the things that he wanted is he wants proof that is actually what the city council members have been saying, with some kind of notes or video excerpts of the city council meeting where they were saying that those things, that their hands are tied and they have to follow this rule.
Okay, that was just your averment. You said that, but you didn't prove it.
Right. I didn't have any stenographer's notes, but that's what the residents of Simi Valley told me. And I've seen a video of it, yes. But we didn't have a flash drive or anything like that. So his idea was, you made the allegation, but you don't have any proof other than the allegation. So
that makes sense. Okay, now I understand. Yeah, I didn't catch it at first, that you didn't have proof that the city council members were saying that if they did not implement 5G in Simi Valley, they would be sanctioned by who? The federal government and fined?
Yes. That's what they've been telling the residents, that the federal government is going to sanction them and have lawsuits against them if they didn't follow this rule and implement this 5G rollout in Simi Valley. Now, when they met, go on, I'm sorry.
No, you go ahead.
When they met me several months ago in May, I actually did not want to get involved with this at this time, although I've been looking at the 5G stuff for like 4 years. Curious about it, but I hadn't done the research yet, and I was involved in other matters. And so they didn't know how to do the research, so they paid me to do the research, and I told them the first thing you want to do is someone says you got to do something, or you're forbidden from doing something. Have them quote you the statute in verse so that you can go look it up and see, 1, if it exists, and 2, if it applies to you. When you begin to learn to do that, you're going to figure out all kinds of things that don't exist in this country. So I did it for them. I realized Title 47 of the Telecommunications Act came out first in 1934 and then amended in 1996. But it's from a federal agency, the Federal Communications Commission. And when I read all those titles, it's an administrative law by which the FCC regulates telecommunications companies who want to sell internet, phone, and cable throughout America. Now, that's one portion. Because it's a federal agency, there has to be implementing regulations of enforcement under the Code of Federal Regulations showing who they can enforce those regulations and policies on. I've looked at that body of law also. And the only individuals that they can enforce those regulations on are the telecommunications companies. Nowhere in America is it allowed them to force those things upon any city or township anywhere. But attorneys aren't making that argument, and they should be.
Of course they wouldn't.
In my brief.
Of course they wouldn't. Okay, so so now what I asked you in the email, and this is, I don't want to lose track of this amongst all of my other questions, but now this writ of mandamus, you and the taking standing under beneficial public interest, both of those things were conveyed to me by a Californian named Ron McDonald. Are you familiar with Ron McDonald?
Ron McDonald? No.
Yeah. Okay. And he's had lots of...
Let me pause you there for a second. To reiterate that I already know that piece, I put the California Supreme Court case, called Obelo versus someone, in the header of my opening statement to show that I don't have to have any particular standing under a beneficial interest where there is a public duty to act from an official. We already have the case law already intact in the first page of the pleading, so in case they want to challenge my standing, they could read the case law and say, okay, he knows what he's doing. This is why he's on the pleading. This is why he's in court. But the judge seems to want to either have him at the pleading, and neither has the opposing attorney. That's been codified under California Civil Code of Procedure 1085 on the writ of mandamus procedure, that case law. So as I was doing my research in writ of mandamus, and there are several kinds you can do, I picked up on this in the writ manuals at the law library. I said, this is pretty cool. And I didn't find any other contradictory case law in contradiction of that one from the California Supreme Court. So the judge is playing a gatekeeper. And he's not going to prevail on it, but he's playing gatekeeper. And I know he is, and he knows I'm onto him. So I wanted to offer you that before you move on with the other questions about benefit and interest. It's already in the pleading.
Okay, so now, my question about Ron McDonald, this is, he's been effective using writs of mandamus and writs of prohibito. And so basically, I think where the mandamus, what I didn't understand is where the writ of mandamus fits into your pleading, and how that dovetails into taking standing under beneficial public interest.
Okay, let me break that down for you. Whenever you want to force a public official to do that which is already law that they're ignoring, or they have a particular public duty that needs to be enforced that they're not doing, a writ of mandate is the tool you want to use to do that with. Okay?
So they're already mandated to do something.
Yes.
They're already mandated. Yeah, okay.
And you want the court to reiterate to them by force of rule of court order to do that which is already obligated under their duty to do. Mm-hmm. Does that make sense?
Mm-hmm.
Well, so it's not a typical tort claim action where you're asking for damages, because they'll say they have immunity and they'll get it in court. It's not another kind of declaratory and injunctive relief issue because they'll ask for immunity and they'll get immunity granted to them in court. With a mandamus, all you're asking for the court to do is declare the right of the party and perhaps seek an injunction for their unlawful conduct. One of the duties that I lay out in my pleading is that they have a constitutional duty to be held by their sworn oath to uphold all the laws under the California and United States Constitution. They have a duty to know the laws by which they are sworn to uphold. And some of the laws they are sworn to uphold is the anti-commandeering doctrine under a federal program. Another law they're sworn to uphold is the plain rule doctrine under congressional intent when it comes to a federal agency. That's their duty as a public official. Now, I get it. Some of these council members are regular Joe Blow, Sally soapbox individuals who decided one day they're going to become a public official. They have very limited, if any, constitutional training, but they find themselves in a position of controlling people's lives. That's no excuse to me. The duty of their sworn oath still applies to them. So,
right, they've taken the oath of office. You know, if you've ever heard Sheriff Mack's story from down.
Heard that story.
What's that?
I heard about Sheriff Mack. I know about him.
Yeah. He found out one day he had taken an oath of office to something he hadn't read, so that is their problem. And to know a thing and to be bound to know it are deemed the same in law. Like,
yes.
If you're bound to know something, you have to know it. So tough, yeah.
Well, law is no excuse.
Yep.
So
and
when it comes to public official, they are sworn to uphold the law, and they have a duty to know the law which they swore to uphold. That's just their duty. And if they're not aware of that, when the citizens come and tell them that, they need to pause and take a look at their deficiency and take a look at the law which they are going to violate, which is what they've done here.
So can you
you cut out there for a second.
This looks like, was it just one pleading, the writ of mandamus, where you were saying, hey, Simi Valley, you've got to,
I'm sorry, I missed your question.
Okay. Tell us all the paperwork you put so far on this. What does it look like? All of your paperwork.
Okay. Well, the first thing we did was give the city a cease and desist notice that the 5G, the federal rule 18-133, was a federal order that the FCC gave down to the telecommunications company, not the city. It doesn't pertain to the city. But the attorneys who are working with the city as consultants are telling them that it does. So we sent that notice to have them cease and desist the 5G rollout, and they didn't respond to it. So we're using that as a basis, first basis, that the people have the right to instruct their representatives under California law. And we sent them instructions under Article 1, Section 3A. They ignored the instructions. And they have a duty to respond to it. Okay? So the next piece, the mandamus in court, is asking the court to recognize this right under California's Constitution and recognize their duty to force them to do their duty, to abide by the oath, specifically to these laws. So in the pleading, I mentioned federal regulatory order from the FCC 18-133, and I'm now going to submit the whole order in its entirety, all 137 pages. I didn't last time. I thought it was just too much. I'm going to submit that as an exhibit. I have submitted their oath of offices as judicial notice for each council member that they definitely have sworn an oath. Mm-hmm. I'm going to be submitting the parallel table of authorities from the CFRs to show that none of Title 47 is impacted upon the public. I'm going to be submitting by another exhibit either a flash drive of the city council members' statements, what they said by video, to prove that they have to set these things. Mm-hmm. And I'm going to be submitting what's called a constitutional challenge to my standing issue by another mandamus directed at the judge himself. So that's what's going to be submitted next week. Okay. And the reason I ask that really is just to give people an idea of what kind of, how much actual work is involved in standing up against 5G. Well, I mean, one of the problems is all of the narratives that have been expounded by the professional attorneys are ignoring the law issue. Does it impact? Is there a code of federal regulation that states specifically that the FCC can enforce this rule upon the public? They're missing that piece. You probably heard about the League of Cities lawsuit in the Ninth Circuit that's been on this year, where hundreds of cities, represented by several attorneys, have been up at the Ninth Circuit in an administrative procedure lawsuit. And they're arguing issues like shot clocks and environmental issues. Now, environmental issues should be raised, yes, from the safety of these RF waves, but if you don't raise what's called an authority regulation, then you waive the other issues. You waive that issue. Now, for me, and I've explained this to the people that are on this brief with me, the Ninth Circuit Court of Appeals in this ADA, Administrative Procedures Act, in this League of Cities lawsuit, these attorneys and the cities should not even be there. They lack standing to be there. This is where the FCC has an issue with a telecom company who's trying to get a license or a signal or whatever to sell and send out to the American public. They have no standing to be there, but they're running them in droves, a paddle, making these frivolous arguments. So that's part of the problem. And
well, lots of times it seems to me that they just throw something out there and try something and just see if nobody objects. And just
here's the thing: if you're in a lawsuit with a judge, now in district court is a little different in terms of regular civil action, but if you run into an administrative procedure like this, the judge panel is not going to tell you you don't have any standing, get out, because they're corrupt. They're going to let you argue these frivolous issues and make these rulings that don't apply to anybody but the telecom company, and it might be misconstrued, and so forth. But the attorneys get paid hundreds of thousands of dollars by these cities to go up there and make these frivolous arguments, draft all these heavy paperwork pleadings about these frivolous issues that they should not be making, because the only people who should be making those arguments should be telecom attorneys. But they're doing it. They're getting paid for it. They get billable hours, but that is what they're doing. It's a waste of time and effort, okay? Because the FCC, as a federal agency, has no authority, unless by regulation, to enforce any rule on a city or township anywhere in America, and that's how Congress set it up. So remember this rule. When it comes to a federal agency, the regulations of enforcement rule. They don't make – federal agencies cannot make law.
Right.
They can only regulate according to congressional intent.
Yeah.
So
and are you familiar with Mack and Prince versus United States and
yes.
which the Supreme Court parsed that?
That's in my brief.
Yeah. Okay.
Those are in my brief.
Yeah, that's a great one for regulatory. The states aren't to be carrying out federal regulatory.
Right. So for the judge, if the judge is making a claim that Title 47 is law, then his argument comes dead smack in conflict with the anti-commandeering doctrine and the plain statement rule of Congress. He can't have it both ways, okay? But that's what he's claiming right now.
Can you explain those? I'm not picking up on exactly how that works.
Which part?
The plain statement and the commandeering. Okay. I'm not getting it.
The anti-commandeering doctrine, I'll first give you an analysis of where a federal agency or even Congress tries to overrun its what's called authority and enforce a federal rule upon the states. Now, states have their sovereign rights also, okay, when it comes to some of these rules and regulations. So Congress doesn't have the authority to enforce a state to do any federal program unless the state does so by contract and agreement. For example, the Brady Bill, which Sheriff Ricky Mack challenged in 96 or 95. In that particular storyline, the DOJ was trying to get him to enforce the Brady Bill in his county in Arizona. He was not going to do it. The Second Amendment prevailed. It preempts it. The district court agreed with him, and that was the ruling because of the anti-commandeering doctrine. Okay?
Mm-hmm.
The DOJ can't enforce this federal rule nowhere but inside of D.C. and those federal territories, period. But it took Richard Mack taking a task. So the anti-commandeering doctrine speaks to that issue. Now, The plain statement rule is a rule where Congress, there's Supreme Court cases also where when it comes to a federal program or a federal rule, let's say that if I were to take the judge's assertion that Title 47 is law, then Congress would have had a plain statement rule in the regulations, either in Title 47 or the Code of Federal Regulations that clearly stated it is congressional intent that Congress mandate or allow or this agency to enforce upon the public these particular regulations and this activity. You don't see that language anywhere in Title 47 or in the Code of Federal Regulations, 47 CFRs. It's not there because Congress never put that language in there, which means that agency, the FCC, has no authority to enforce regulatory number 18-133 upon anyone except the telecom company.
Okay. Now, I'm just going to mention what is going on here in Alaska. We don't have counties, but we have boroughs, and it's not the city government that's putting in 5G, it's the borough government, and they have turned it over to the electric utility to do.
Still unlawful. According to the anti-commandeering doctrine, no city or township can be forced or allowed to do that, even if they consented to. So when you get the case law on the Prince case in U.S. versus California, that's what it states. Even if the township wanted to do it, they can't do it. It violates the sovereign authority of the state where the federal government tries to impose its will upon the state, and it cannot do so. So you have boroughs, they serve the same capacity as a township or a city or a municipality in Alaska. Mm-hmm. So the same rule applies, though.
So basically, the borough can't do it, and they don't have any authority to pass it off onto the utility to do it.
No, they do not.
Okay. So now back to your comment, and I'll just do one more, and then I'll open up the floor for questions. But in regards to instructing your public officials, are you familiar at all with petitions for redress and remonstrance? I'm going to read. Yes. I'll read. Okay. All right. Yes. So the courts of justice are in the legislature, not in the courts of law.
Okay.
Okay. So this is what our proclamation and our new task force is about. And I can get you some information on the guy that has come up with what's going on in both the federal Congress as well as state Congresses.
Okay.
In regards to redress and remonstrance, and I just wanted to read for the benefit of the show here. We just got off the phone tonight with our good friend from New Hampshire. And he said, look at the New Hampshire Constitution. And he said, look at Part 1, which is their Declaration of Rights, Articles 31 and 32. The purpose, meetings of the legislature, for what purpose? Is Article 31. The legislature shall assemble for the redress of public grievances and for making such laws as the public good may require. So the primary issue legislature shall assemble in the first place is for redress of public grievances. Article 32, and I will send these out to everybody after tonight's show so you have them. Article 32 is rights of assembly, instruction, and petition. So that hits right on what you're talking about. How do you instruct? The people have a right in an orderly and peaceable manner to assemble and consult upon the common good, give instructions to their representatives, and to request of the legislative body by way of petition or remonstrance redress of the wrongs done them and of the grievances they suffer. That term remonstrance is what you're talking about. That's instructing the legislature. It's instructing Simi Valley, but you're not doing it in a court of law.
You look up the word petition in law. The petition could be a complaint, as you know.
I do know.
So,
I do know. It's a prayer. It's begging. I understand that.
Right.
However, as one of the people, this is where we're at. We're doing this from our capacity as one of the people or as man. Mm-hmm. And these are not petitions in the strict sense of the word, because if you're going to give instruction, how do you take a subservient role? They're basically claims. You're not in a subservient capacity when you're remonstrating your legislature. You're in the
Correct.
capacity as a creator. So I think we're going to follow through. We've been seeing good results. And people really aren't parsing that particular sentiment, just kind of going over and kind of ignoring it. But it's remonstrance and redress. But in the courts of justice. So that would be your petition is what calls the legislature into a joint session. So maybe that's a local body. Maybe it's a body within the state that you're in, or maybe it's in the Congress of the United States, in that legislature.
Have you discovered a rule that specifically lays out where and how a remonstrance is filed, or a petition in that context?
Well, it's in. Look at 2020, the 2010 edition of Mason's Rules of Legislative Procedure, Section 148.
Okay.
Subsections 2 and 4. Yeah, it's a 148. You're calling them into a session of the decision-making body. This is from Gus today, and I thought this was pretty interesting. When the legislature, the House and the Senate, say in your state of California legislature, are called into a joint session for the purpose of redress and remonstrance, they're no longer the legislature, but they're actually the general court. And it's just what we're seeing in the federal legislature today.
Okay.
The House assembled they have the sole power of impeachment, but that Senate was a court.
Right, correct.
So this is the same mechanism that's going on in the states.
I like it.
Yeah.
I was in touch with a guy named Mr. Gentry from Tennessee a few months ago, and his remarks.
Oh, yeah.
And we spoke on the phone twice. I have some of his documentation. He's done a great job in putting it together. But I haven't yet had time to go through the rules, and I know who I am. I'm going to look at all the rules to find out what I can and cannot do and on what basis, based on the rules. So,
and John was working with Chris Hallett out of Florida, and he's the guy who actually discovered he discovered this based on his reading of the Mason's Manual.
Mm-hmm.
And it's kind of a long, involved story, but the way he approaches this is from his what he does in his private enterprise, and that is loss prevention. And it's really interesting because he says everybody is motivated to hear these petitions because it creates a situation where the state can engage in loss prevention. I think that works by impeaching bad actors. So you bring your petition in, you say, hey, impeach this guy, he's lawless. Here's what he's done. And they're motivated to impeach bad actors because now it's not coming under their bond. They distance themselves. that's my best reading. I can't tell you that that's absolute, but that's my best reading of the situation. That's how loss prevention is playing into this. But it doesn't have to be that way. I mean, this is just a basic right. You have the right to instruct. You have the right to redress. I mean, these are constitutional. The first day we called our legislature here in Alaska and talked to the petitions go in to the House of Representatives to the chief clerk's office in your state. The first day we talked to them, they went to the Department of Law and got back with us in an hour and said, hey, you're right. You have the right. You have both the federal and the constitutional right to redress. And we said, okay, great. We know that.
It's the First Amendment.
Huh?
It's the First Amendment right also under the federal
Constitution. Yeah, absolutely. Yeah. If you can read up to the First Amendment, maybe you've got, maybe you can, exactly, that's what we've been telling people. Go back and read your First Amendment and understand it says you have the right to peaceably assemble your government and redress them. It's all basically one clause. You're assembling your government via the petition. Okay. For the redress of grievances. So it's pretty cutting edge. It's pretty, it's old technology made new again. So we're pretty excited about it. I'm sorry, go ahead.
Have you discovered in that process called the remonstrance the end game of how do you get these officials to honor their oath and honor the citizens' rights in your petition? What are you seeking to do with your petition other than just redress? See, for me, if you're going to redress and you have grievances, you have to have something that you want out of the deal. What are you petitioning for? What are you trying to correct?
Okay, my understanding, and again, I'm pretty new to this, but redress has a dollar amount attached. Okay, actually maybe it doesn't. You're saying I've been harmed, I've been injured, I've suffered this loss, harm, injury, or loss, and you're saying this is at the hands of one of your actors. Somebody exceeded their jurisdiction. They went outside their lawful office. They had an oath of office and they didn't uphold it. And so I need to be made whole in this way. Remonstrance would be that you're giving instruction and you're not asking to be made whole in a financial way.
Very good. Now, with the remonstrance, you're giving instructions. Now, as long as those instructions are constitutional, then they should, if they decide not to abide by your instructions, what are your next moves?
Don't know.
That's what I want to find out before I go into a remonstrance. I want to know every play, every procedure. I want to know the whys, everything.
Yeah,
I have no research yet.
Get on to eClause LLC and on to Kirk's Law Corner. Those are both at least on YouTube, and then they'll send you over to their.
Yes, I would have to also read Mason's procedures on legislative procedures as well to get accustomed to their rules of procedure, law and procedure.
And there is a 2020 edition out now. It's easy reading.
Okay. But
it's where do you find it? NCLS, I think, National Committee for State Legislatures, but if you just look for Mason's Manual of Legislative.
Yeah, I mean, I'm sure I can find a PDF version to download to read that stuff. I just haven't yet had the time to get into that yet.
Yeah, this is like the new latest thing in the Patriot movement is everybody's walking around with their Mason's Manuals of Legislative Procedure.
That's good.
So generally what I study is common law and in contrast to civil law and the origin and growth of it so that I can help people restore their their knowledge and understanding of what we started with. And this, to me, is very well aligned with that. We're just talking about our Bills of Rights, and those are, Bills of Rights are declaratory of the common law. So to me, this is so simple, the perspective of being one of the people of one of the states, that if you're infringed in any of your rights, that you've got a place to go, and you've got an immediate place to go. You're not going to be looking at hiring an attorney to help you. All you have to be able to do is articulate this on paper in the form of an affidavit or in the form of a declaration of truth. So it's simple, but it may be simple, but it may take some work to get the legislature to understand that the reason that they assemble in the first place is for the redress of public grievances. They've forgotten that, I'm certain.
Yes.
So anyway, with that, maybe go ahead and make your comment, and then we'll open up the floor.
Oh, go ahead, open the floor, because I was just echoing what you already said. They have forgotten their role as a public servant.
All right. Okay. Speak up if you have a question, please.
I actually do have a question. For somebody that's just starting, that really has no knowledge, but they're fascinated and would like to get into studying, where's a good point? What's a good book or video, or where can people start?
I would suggest that you start YouTubing Michael Brown's, some of his videos. You won't find all of them online, but you'll find a few of them online. So you'll find his paperwork in a website called RommelLaw.com from the German General Erwin Rommel. He has a school, a digital school called Erwin Rommel School of Law, and you'll find it at the website Rommel Law, ROMMELLAW.com, RommelLaw.com. Click on that. You'll see you can order some material to help you understand the CAS legal system, how to put together a pleading, how to make a judge behave, just some of the rules of law and process that one would need to know if you're going to be inside a courtroom, whether you're a plaintiff or a defendant, particularly being a defendant. So I would recommend some of you start there as well. Now, there's other resources too, but that's a good place to start.
Thank you very much. I really appreciate that, because it seems overwhelming. So any leap-off point would be excellent, and that was plenty. Thank you so much.
Okay. No other questions?
Any other questions? Or comments?
I'd just like to say thank you. Really, that's amazing. Thank you for sharing all your knowledge and getting it out there to everybody. That is awesome.
You're welcome. My pleasure. I have a number of years, like 17 years of research study, about 10 years of court experience, federal and state court. So I really learned a lot about what to expect in the courtroom, how to handle yourself in the court, how to give good oral argument, how to make a constitutional argument in court. You don't want to get into court and be not prepared or understand what your argument is about legally. One of the things that Brown talks about is if you expound or invoke an argument, no matter what it is, you should have some way to prove and back up and counter-argue in front of a judge your argument. Now, some people, over the last 20 years, I've talked about common law liens and common law this. One of the things I recommend you pick up, if you can get it digitally, is Blackstone's commentaries on common law. I have a 2-volume set that I'm trying to get through now. It's very good. Common law seems to be this elusive thing that our court systems will indicate sometimes in their rulings, but they won't go into details about the common law. The Magna Carta, understand that our laws in this country come from 4 different areas. English common law, it comes from the Roman civil law, the Mosaic Code of the Bible, and the Uniform Commercial Code. Okay? It has 4 different laws entwined, and pursuant to H.J.R. 192 of our bankruptcy in 1933, those have gotten muddy in terms of the type of courts you get involved in, whether it be an administrative bankruptcy tribunal under the Reorganization Act, or you dealing with another kind of court. But it's going to be hard. These judges, because they know of the bankruptcy, they try to ignore the Constitution. So it's a challenge to navigate a system so corrupt. Okay? But it is doable. But you want to know some of those things about courts before you enter them. Now, for me, because I understand real succinctly about an admiralty jurisdiction, I know how to go into court and argue those points in front of a judge such that he will not dispute acts of Congress against me. So if you're going to argue it's a military tribunal, you need to know what basis you're basing this argument on and be able to articulate that in front of the judge. So you want to point to one of those things is H.J.R. 192, June the 5th, 1933. It's a military tribunal. It's a admiralty jurisdiction. It's the gold fringe flag.
Can you give us kind of the basics on... Oh, is that you, Debbie? Oh.
Yes, it is. For the man in California with the 5G issues, I would say just Deborah, her last name begins with a T. I think it's like Traveris. Her website is stopthecrime.net. She also has a YouTube channel. She has been fighting this 5G fight for years, and she's all over that, and I bet you could team up with her. I believe she's in Sonoma Valley. Have you heard of her?
I have not.
Okay, well, she's all over this, and for as far as your redresses, you could do this. This is really a much simpler issue going through this redress process because it's a process and they cannot get away from the process. That's how come President Trump prevailed in this impeachment. My takeaway from Jay Sekulow, and I'm going to keep it for the rest of my life, all these things that they're doing to us, he put it in one sentence. He said, you still have to meet the basic constitutional obligations. They're all violating their oaths. And in
Correct.
Tonight, Kirk and Chris Hallett's show, Kirk's Law Show tonight, they showed how easy this redress process is by commenting that, we all ought to put a one-page remonstrance in to the judiciary and to have Pelosi retire. Now would be a good time for you to retire. We have to instruct our representatives. Those representatives just happen to be in Congress. But tonight was a really, really good lesson on Kirk's Law having to do with our history of our law, the foundations, the successions, and you can't get away from this, the Constitution. That's just the bottom line. And all of this stuff that you're going through in the court, you're going to be singing the same tune a year from now. They don't want to hear you, and they're going to waste your time. And this is what Debbie has been going through with the StopTheCrime.net fight. She's been fighting this for a lot of years. Check out her YouTube channel. I yield.
Okay, thank you.
Thank you, Debbie.
I have a question.
Go ahead.
This lady Debbie just spoke about the people in either Alaska or in Washington as being her representatives. I'm not so sure I can buy that routine, because to me, that corporation in Washington, D.C. is not abiding by the Constitution for the United States of America. They have several constitutions that say United States constitutions, but they don't say for the United States of America. And these representatives, I'm sure it's not different in Alaska than it is here in California. Those other constitutions are the one they put their hands on and take the oath on. And that is to support that corporation, which the state of Alaska is a subsidiary quasi-corporation of that corporation in Washington, D.C. And if we go into, there was a mention about common law. I'd like to ask anybody on here, and I think Travis and I know each other, but I would say, show me an Article 3 court where you could go into with common law in this country. And I don't think you're going to find one in Alaska. You won't find one here in California, because they're all military tribunals. And if you want to look when you go into a court, look at the flag. And what you'll see on that flag is gold fringe. That does not mean it's a common law court, period. It means it's a military tribunal using commercial contracts, and you have an executive administrator, not a judge.
You are correct. You're absolutely correct. They are admiralty courts. And there's an executive order about maybe 18 months ago about transferring over to common law courts. And the new 185 federal judges that President Trump just put in, they're all constitutional judges, and that whole system is being reworked. In the meantime, a simple redress to say, Nancy Pelosi, please go home. We'll discuss this with her later. We have really emergency situation going on right now.
I'm not disagreeing with you. I understand we have some serious situations, yes. But I think my question was, show me the court, an Article 3 court that you can go into. That is determining common law. Everything else is commercial contracts.
That's right. You're right.
And if you are a U.S. citizen, you have no standing in a court of law. On Article 3, that's why you're in commercial courts.
Can we get your input, Travis?
Travis. Yes. Yeah. All of the federal courts these days are seated under Article 4, not Article 3. The administrative tribunals.
May I short point?
I'm sorry?
May I, Maria?
Yeah, please go ahead.
Yes. Prior to the Tompkin versus Erie Railroad case, we did have Article 3 courts. We did have common law in our courts, but once the Tompkin versus Erie Railroad case happened, our entire system switched over to contract law.
Yes.
Which they use maritime. I yield.
Thank you.
May I say something, just briefly?
Please go ahead.
Yes. It's reported that in the state of California, just an average man or woman walking on the land cannot walk into a county clerk office and record anything. And also, if you go into a courtroom, they've taken the recorders out. So there is no public record, reportedly, in the courts in the state of California, and they are vacant. That's the report. Thanks.
Does that require one in California to be able to ask the judge, is this a court of record? And if Travis, you could comment on this too, you'd have to say, is this a court of record? And if he says yes, then that means the reporter's there. If they're not, then he's going to say no, or she, whichever. And then you could say, well, then this case needs to be moved from this court to a court of record.
Well, you're correct. I don't know if that's the correct procedure for that, but I can tell you this based on my experience in the courtroom. One needs to be aware of the fact that in California, some of these venues, like in Ventura, have such a heavy docket, that they're basically telling people, we don't really have access, and we're not going to provide a court reporter the time you need one. However, under California's Constitution, it states that all California courts are courts of record. Now, that being the case, if you put a notice in demand like I did in front of your petition, demanding a court of record, the judge sets up either recording device or stenographer, they're supposed to do it. I've had one judge removed from the bench for not doing so. So this judge in Ventura provided the court with a court stenographer in my mandamus case. So I'm not sure if, if as a litigant, if you walk into court and you're an observant and you know what the court should be set up like, and you don't see a stenographer, I guess I would ask, Your Honor, is this a court of record and are we on the record? If he says no, then we need to postpone these proceedings or move to a court of record.
Yes.
He can do either one.
May I?
Go ahead. Yes.
There is another way that was discovered. It's been shared. It's not widely known yet. And I was directly involved with helping someone do the process, and it worked out awesome. It completely set the court upside down. The prosecutor apologized to the defendant for violating her rights. And what it did was I had the defendant take the judge's oath and accept it as a contract to uphold her God-given and constitutional rights. The judge puts that oath out there as an offer of contract, but nobody accepts it. Therefore, the judge is not bound by it or the Constitution. They do whatever they want. But once somebody accepts that oath as a contract, it completely flips everything upside down, and it's all in the defendant's favor. This was proven by Valerie Willis in Michigan, who is on ballot right now to become a United States Senator. They were demonizing her. They stole one home from her. They were trying to steal a second. They were trying to put her in jail. They were trying to shut her down because she wants to do to Michigan what Trump did to the entire America. And they were scared to death of her. But when she started doing that and seeing the effect of it, everyone she run across, she's accepting her oath as a contract. Even the governor, all of them, the sheriffs, it doesn't matter. Anybody in any public office, she accepts their oath as a contract. It's become a storm. And it is successful. I yield.
Very good. Any more questions?
Oh, I do have one other point I'd like to bring up.
Go ahead, Destry.
This dirtball scumbag Adam Schiff brought up to a comment out that really caught my attention. It wasn't the threat of it that caught my attention. It was just the fact that it was in the back of his mind that caught my attention. He, through the statement where he was questioning if Donald Trump would sell Alaska back to Russia for election assistance. Just the point that he threw that out there about selling Alaska back to Russia, he didn't just create that out of the blue. That's something that's been in the back of their minds for a while. Something he's dwindled on, thought about. And if that possibility even exists, that I do not like that at all. What are we? Chattel to be sold? No.
Yes.
Alaska was purchased from Russia and was a military district since 1863. It was incorporated 1859 with a corporate charter constitution. The people, to this day, have never settled Alaska. Until the people settle Alaska, it will remain a corporate charter, a fiction, and something that can be traded. When the people settle Alaska, self-govern, it automatically nullifies the corporation. American Jurisprudence, Book 38A, page 340, first line. Abraham Lincoln's General Order 100, issued 1863. Until the people return to self-governing, the United States military or the military-industrial complex will run the country. So if we want to wash our hands of all this malarkey that we've been dealing with and trying to battle, and we figure something out and they change the rules and we got to start over, instead of butting our heads against them all the time, I mean, we could be doing this for hundreds of years. If we just return to self-governing, settle this state, provide our oversight, they go away by default. I think that'd be the easiest thing to do and the least headache. The biggest problem doing that is you got so many people don't want to do it. They want to wait for somebody else to do it.
Yes.
Okay, so I'm going to interrupt a minute, Destry, and we can get on to that. I feel like we need to make sure we wrap up with Travis a little bit here. I want to go back for a minute and read this, the segment in Kirk Pendergast's letter accepting the oath of office. So basically, he says the oath. Oh, let me get off speaker. The oath of office. He's right. The servant. He says the oath of office being your open and binding and irrevocable offer, to which my acceptance does hereby ratify into a firm and binding private bilateral contract between us, by which you agree to uphold the supreme law of the land, also known as the Constitution of the United States of America, with the Bill of Rights.
That's 4.
And to it should be 4, but this is what his letter says. With the Bill of Rights, and to perform all of your duties as a public servant, and it goes on, but it's basically saying when they hold up their hand and take the oath of office, that is their open, binding, and irrevocable offer, and my acceptance in writing then creates a firm, binding, private, bilateral contract. So my read on that is that, okay, if you guys are going to insist we're in contract law, we're in commercial law, then this is the basis for the contract between us. Okay, and then I just want to real quick also now get comments on any of that and give Travis a minute or two to just make closing comments, and we can let you go for the evening. We've been on an hour and a half.
Okay. A comment on the oath of office as a contract. I think that's a great idea if you can get a judge's attention to adhere to it or make him feel threatened by it and see his liability. Now, as I listen to the verbiage, I think I know how I could force a judge's hand within that verbiage to make him see his liability. Let's say if he wanted to scram out of the contract or do something other than what the contract permits, like violate rights, that comes down to an obstruction of justice charge against him. And I've had 2 judges removed from the bench by hitting him with a racketeering case. So I see the possibility and the potential there.
So, okay. So can you walk me through that just a little bit? How would you make that happen? How are you feeling like you could make it?
When you have to be able to prove on the record of a case that a judge derailed the process such that your rights were impaled by the process or something he did directly, he or she.
Okay.
So if he violated your right within a proceeding, let's say he didn't take your testimony as authentic, or he denied you evidence on the record, or he disallowed you to speak, or he made a wrong judicial ruling on your matter that was contrary to the law, those are reasons that you can put him under what's called an obstruction of justice charge under the Hobbs Act for obstructing and racketeering.
Okay. And again, you still have to have the proof that he violated. He went outside of his oath of office and hurt you in the violation of your rights.
You can do that one of two ways. You could have a stenographer taking notes, or a recording device, recording his words, and a judicial ruling to prove the racketeering. That's why when I go into court, I'm looking for a stenographer to be there or a recording device to be there. So I want to capture by evidence of obstruction as it happens.
Right. Yep. There's a great video by Bill Thornton talking about the definition of a court of record, and it's much, much more than just it's being recorded. And one of the most important aspects of it is that it proceeds in accordance to the rules of the common law. So a court of record means there's 5 characteristics, but it is a common law court.
It also preserves your right to appeal.
Well, it keeps a record.
Court of record, yes.
Yeah, it keeps a record, proceeds in accordance with the common law. Tribunal is independent of the magistrate. That's your real jury. They're independent. It's not. They don't just give him an advisory and he makes the decision. But the tribunal is independent of the magistrate. He's just the ref. He can be. The court can imprison for contempt, and generally it has a seal. So it is one of our courts. So if you require a court record, then they will obfuscate. They'll say it's being recorded. Yes, we're on the record, but you need to make sure you know all 5 characteristics so that you actually can have an American court instead of just a civil law tribunal. So anyway, okay. Any closing remarks, parting shots?
Thank you for having me. I really appreciate you all. I learned a lot. It was great. Thank you.
All right. Thanks so much, Shelly. We'll be in touch.
Sounds good. Thank you.
All right. Go ahead.
Right, and thank you, Shelly.
Yes, thank you. I appreciated it all. Thank you very much for everything everybody does.
We can't help ourselves.
Right.
All right.
Well, you can help yourself.
I'm sorry, Travis. I thought you were getting in back there. Go ahead.
Yes, you can help yourselves too if you know what to do and how to do it. There's lots of things you can learn to do.
We would love to have you back to explain to us the ins and outs of what you're talking about, how you make a constitutional argument, the right way to do that in one of these courts. That would be great sometime.
I'd love to. Just let me know when you want to have me back.
All right. Thanks very much, and I guess we'll say good night. If anybody wants to stay on the call, I'll leave it open for more discussion about how we settle our state. And other than that, we'll be back next week, same bat time, same bat channel. Have a great week.
Thanks, guys. Good night.
Good night.
I'm still here.
Welcome to the after party. Oh, I'm going to put out the recording.
Nice.